Susan Gillis at Capital University Law School, and this video will explain the steps in a typical lawsuit. You can use this to understand your initial reading in the Goldberg text, pages 21 to 28, but you can also use it to refer back to in any of your classes whenever you get confused about the steps in a basic civil lawsuit. Let's take a look. The timeline of a lawsuit starts with pleading, goes through discovery, then trial, and then the trial court will enter a judgment declaring one of the parties the winner and the other the loser. We'll take a look at each step. Let's use a typical case. Here the plaintiff was punched in the face by the defendant, causing plaintiff to have a broken nose, miss work, and pain and suffering. So plaintiff wants to sue the defendant in tort. Pleadings. As a first stage, the plaintiff would file a document called a complaint. A complaint sets out the plaintiff's version of the facts, here that the defendant hit her breaking her nose. It also will identify the claim she's making. You will learn in tort that a punch in the face is a tort named battery, and it will also seek relief. In other words, it will tell the court what judgment at the end of the entire process the plaintiff claims. Here the complaint would probably ask for money damages to cover her medical expenses, pain and suffering, any lost work. The defendant will file a responsive pleading called an answer. In the answer, the defendant will address the factual allegations made by the plaintiff. So in our case, the defendant might say, I agree, I admit that I was in the bar. However, I deny that I punched the plaintiff, I merely shoved her. The defendant can also, in their answer, raise affirmative defenses. An example would be self-defense. The answer would say, even if I did punch the plaintiff, it was in self-defense, and so I'm excused from liability. So these two documents, a complaint and an answer, set out the basic claims and defenses of the party. This is known as the pleading stage. The next typical stage you'll see in a lawsuit is discovery. This is where the parties exchange information. For instance, the plaintiff might ask and take the deposition of a defendant, where the defendant is questioned under oath as to what happened. Or the defendant might seek documents, file a request for documents, seeking to find out the plaintiff's medical bills and expenses. So discovery is a stage of the lawsuit where the parties use formal devices to get information from the other side. When the parties have all the information, they're going to go to trial. What happens at trial? The lawyers will put on opening statements where the lawyer will describe to the jury what is going to happen, what evidence they expect to put on. Then the plaintiff first and then the defendant will actually put on witnesses, i.e. introduce evidence to explain to the jury their version of what happened. After all the witnesses, first for the plaintiff and then for the defendant, have been put on the stand, the lawyers will once again speak to the jury. When they speak to the jury after the evidence, it's called closing statements. They'll try and summarize to the jury what they believe their evidence has shown. Then the judge instructs the jury. Jury instructions will explain the law to the jury. Finally, the jury goes back into the jury room and deliberates and will return a verdict. In other words, they will say, for the plaintiff, $50,000, or for the defendant. After the jury brings in the verdict, a formal judgment is entered by the judge. This is the formal statement of the result of the case. Once judgment is entered, the parties can appeal, challenging that result in an appellate court. Let's look at a series of motions which change the timeline for litigation. A motion is simply the name for a request to the judge that the judge issue an order. You can have numerous types of motions. For instance, a motion for extension of time, asking for more time. We're going to look at a series of motions which ask the judge for a shortcut to judgment. In other words, these motions ask the judge to change the straightforward of timeline to judgment and instead skip ahead to judgment, bypassing several of the standard steps. First, a motion to dismiss. When plaintiff files their complaint, the defendant may either answer or may file a motion to dismiss. A motion to dismiss asks the judge to throw out the complaint and immediately enter judgment for the defendant, skipping discovery and trial. When a court's considering a motion to dismiss the complaint, the court must believe all the facts in the complaint and yet still decide, even if I believe everything in the complaint, the defendant must win, so I must enter judgment for the defendant. When would a court grant such a motion? There are several typical scenarios in which courts grant motions to dismiss. First, the plaintiff may have made a serious procedural error. For instance, if the plaintiff filed her complaint, her pleading, in the wrong court, then even if the judge believes everything in the plaintiff's complaint about how the fight took place, because the complaint is in the wrong court, the judge must grant the defendant's motion to dismiss and enter judgment for the defendant. So serious process errors can lead to the granting of a motion to dismiss. Another ground on which courts will grant a motion to dismiss is if there's a serious defect in the pleading of the complaint. So when the court looks at the complaint itself filed by the plaintiff, it says, even if I believe everything plaintiff says, there are omissions of key facts or theories which render the pleading insufficient. Because the complaint is drafted so poorly, I'll grant a motion to dismiss because the defendant has to win. The defendant is entitled to judgment on this complaint. Sometimes you'll also see motions to dismiss being granted because the plaintiff waited too long to be filed. Statute of limitations require plaintiffs to file their complaint within a certain amount of time of the incident. So if plaintiff waits too long to file her pleading, defendant is entitled to judgment because the plaintiff has simply waited too long. Finally, you'll sometimes see motions to dismiss being granted because plaintiff got the law completely wrong. So for instance, if plaintiff's complaint alleges that defendant frowned at her, even if the judge believed all the facts in the complaint that the defendant did frown at the plaintiff, the court would still grant a motion to dismiss because tort law does not recognize a claim for frowning. So the court would say the complaint is defective because it fails to state a proper claim, so defendant's motion for dismiss is granted and judgment is entered for the defendant. That's our first shortcut, straight from the complaint to judgment. Let's look at the next bypass route. The next bypass is called a motion for summary judgment. This motion is typically made during discovery, and as you'll see, the motion argues that there's no need for a trial. Instead, the court should simply grant judgment. A motion for summary judgment is typically made by a defendant, but it can be made by a plaintiff. What showing needs to be made? Remember, the argument that the movant, the person filing the motion, makes is there's no need for a trial. When would we not need a jury trial? To get the motion granted, you have to show there's no genuine dispute of material fact. In other words, there are no material facts that a jury would need to decide. Secondly, you would have to show that your case is a must-win. A must-win is a colloquial phrase. Instead, the standard is that no reasonable jury could find for the person opposing the motion. No reasonable jury could find for the party opposing the motion. If the movement shows there's no factual dispute and no reasonable jury could find for the other party, there's no need to ask a jury, there's no need to have a trial, and we simply enter judgment. You might wonder how a motion for summary judgment is different from a motion to dismiss. A motion for summary judgment, the court looks not just at the complaint, but it will also look at the written record, the written information the parties have gathered during discovery. So a motion for summary judgment is often accompanied by documents the parties have obtained during discovery, extracts of depositions or affidavits where parties make statements under oath. And it is on this paper record that the court decides whether or not to grant summary judgment and skip a trial. Let's look at the next key motion. The next key motion occurs during trial. Once again, this is a motion asking the court to enter judgment because no reasonable jury could find for the party opposing the motion. Here, we're simply skipping the verdict. So the motion is filed during trial as the evidence is being presented, and when one side has presented its evidence, for instance here if plaintiff had put on all her evidence, the defendant could say to the judge, I move for judgment as a matter of law because even if you believe all the evidence plaintiff has put in at trial, I'm entitled to win. No reasonable jury could find for the plaintiff, so therefore there's no need for a verdict, there's no need to ask the jury. Equally, the plaintiff could make a motion saying, given my evidence and all the evidence defendant has put in, I'm entitled to judgment as a matter of law because no reasonable jury could find for the defendant given the evidence that's been put in at trial. So this is again a shortcut to judgment, and it shortcuts the jury's verdict. For this reason, although we now call the motion a motion for judgment as a matter of law, at one time it was called a motion for directed verdict because it directed how the verdict would come out. Our last two motions are post-trial motions. A motion for judgment as a matter of law can be filed after the jury verdict, after judgment. This time, the motion asks for an overturning, a reversal of the jury's verdict. For instance, if the judgment went against the defendant, the plaintiff, for instance, was awarded $50,000 on a battery claim, the defendant could file a post-trial motion saying that as a matter of law, the jury got it wrong. No reasonable jury should have found and entered a verdict for the plaintiff, so the court should overturn the plaintiff's verdict and enter judgment instead for the defendant. As you can see, this is a hard motion to win. You have to convince the judge that no reasonable jury could have reached the verdict that this jury in fact brought in. The second motion that you can file after the trial is a new trial motion. A new trial motion asks the court to undo the judgment and then to have a new trial. In other words, to impanel a new jury and to hear the evidence over again and let a new jury bring in a new verdict. So it is in a sense a request for a do-over, that you go back and redo a new trial. Why would a court grant a new trial? A new trial is granted if there's some kind of procedural irregularity in the old trial. For instance, the jury instructions were wrong. A juror watched a report of the case on television considering outside information. Or, for instance, perhaps the lawyer's closing argument was inappropriate. Any of these procedural irregularities could lead a judge to grant a new trial and ask a new jury to hear the evidence all over again. A new trial can also be granted if the size of the verdict, the amount of money awarded, appears to be the product of passion and prejudice. So, for instance, if the jury awarded this plaintiff $50 million for a broken nose, the court might well grant a motion for new trial and have a new jury evaluate the value of plaintiff's claim. Finally, a new trial motion can be granted if the verdict is against the great weight or the clear weight of the evidence. The judge is not prepared to say that no reasonable jury could reach that result, so the court is not willing to grant a motion for judgment as a matter of law. However, the court is troubled by the verdict. It feels the verdict is against the great weight of the evidence, so it simply asks another jury to reweigh that evidence. So these are the two key post-judgment motions, post-trial motions that you will see in a civil lawsuit. I hope this trip through the stages of litigation and the various motions that can be filed is helpful. Remember, you will likely be reading a decision of an appellate court where the appellate court looks back through this timeline of litigation to assess if errors were made by the trial judge during the litigation. One final note might be helpful. You should have observed during our discussion the very different roles that judges and juries play in the litigation process. Judges rule on all the motions we've discussed. They also decide the law. It would be a judge that decides if tort law recognizes a claim for frowning. Equally, judges supervise every step of the litigation we've discussed, the pleading stage, the trial, ruling on objections, giving the jury instructions. Finally, after the jury has brought in the verdict, it's the judge that enters the judgment in the case. In contrast, the jury's role is confined to the trial stage of litigation. The jury must decide the facts. They also decide how the law applies to the facts. So if the law says the defendant must exercise reasonable care, the jury would decide both what defendant did, the facts, and whether that constituted reasonable care. The jury also decide who to believe, credibility, and they will also weigh the evidence to see if the plaintiff has met their burden of proof. After all, it is the plaintiff who in a civil case must put forward the preponderance of the evidence, showing that it's more likely than not that their claim is supported by the evidence. Finally, the jury returns the verdict, which is then entered as a judgment. Feel free to ask me any questions about the litigation timeline or about the role of the judge and the jury. I hope this has been helpful. I'll see you in class.